I'd like to welcome everyone this evening to the latest in the Penn Law Washington Seminar Series. I'm Mike Fitz, I'm the Dean of Penn Law School, and this has been a series in which we've focused on, I think, some of the most important policy issues facing our country in a nonpartisan way, but hopefully a spirited way and a thoughtful way. With some of the leading experts on those topics, both in Washington and elsewhere. I think there are a few topics that are both more important and have caused more heated discussion than the issue of drones and targeted killings, though maybe today the strategy of the Internal Revenue Service for selecting who they're going to investigate is close by in that category. It is obviously a central policy issue, but for somebody like myself, who is a law dean, it also tests some of our most fundamental debates about legal rules, constitutional issues, and the like, and obviously it's very fastly evolving. Since 2004, there have been 430 drone strikes, at least as far as we know, in which somewhere between 2,500 and 4,000 individuals have been killed. Obviously, we're a long way from James Bond in terms of the impact of this. There are sort of three separate issues, quickly I want to go over, that we'll cover in this discussion. The first is sort of generally the question of law of war. Is this a war? What are the legal rules that apply in the application of coercive power in a circumstance like this? Secondly, the separation of powers issues. What does it say about the relationship between the branches of government, the executive branch, congressional oversight, the judiciary, transparency? How do we have shared power in making these decisions? And then finally, we have the general political framework and changing politics both domestically and internationally in a reaction to this, as well as evolving technology. We have really an all-star panel to discuss this. To my right is Mark Mazzetti. He's the intelligence correspondent for the New York Times. He's also intelligent, but in terms of subject matter area, the intelligence correspondent for the New York Times, where he's covered national security for the Washington Bureau since 2006. In 2009, he shared a Pulitzer Prize for his reporting on the intensifying violence in Pakistan and Afghanistan. Before he joined the New York Times, he covered the Pentagon for the Los Angeles Times, and prior to that was national security correspondent for the U.S. News and World Report. I should note he has a new book out that has had very positive reviews, The Way of the Knife, The CIA, A Secret Army, and a War at the Ends of the Earth. And we actually have copies available, and I know he'd be happy to sign them after the discussion this afternoon. Secondly, to my far left is Professor Claire Finkelstein, who is the Algernon Biddle Professor of Law and Philosophy at the University of Pennsylvania Law School, as well as director of our Center for the Ethics and the Rule of Law. She is co-author and editor most recently of Targeted Killings, Law and Morality in an Asymmetrical World, has done a lot of work bringing together professors in philosophy as well as individuals involved in the program itself. Her book will also be on sale afterward, and I'm sure she'll be happy to sign it. And then finally, we have Peter Singer, who is Senior Fellow at Brookings and Director of their Center for the 21st Century Security and Intelligence. His research focuses on a number of issues, but they include the future of war, current U.S. defense needs and future priorities, as well as the future of the U.S. defense system. He's author of a number of books and articles, but most prominently for these purposes, Wired for War, The Robotics Revolution and Conflict in the 21st Century. He's one of the world's leading experts on changes in 21st century warfare. The format is going to be conversational, not long speeches, but back and forth questions between members of the panel, dividing up in these three general areas. And then at the end, we'll open it up to questions from the audience. And hopefully this will be a robust conversation about where we are, and where we will be or should be going. Anyway, I would like to start out with Mark, who's written a lot about the history of this entire program and how it changed over time from the Bush administration to the Obama administration. And I wonder if you could just give us the framework for the program, the targeted killing program with drones as it evolved after 9/11.
Sure, and thank you for having me here tonight. It's a tremendous honor to be with this group. Claire, who I just met, and I look forward to reading her new book, and Peter, who has been a long source of insight for reporters who are ignorant about issues. And we call him, and he provides us with tremendous insight and guidance, and his book is really the first definitive work on drones, and it's really terrific. So it's great to be here. And to your question, so the sort of brief history of the last 12 years in 3 minutes or so, but basically, shortly after 9/11, President Bush gave a sweeping authorization to the CIA to carry out a global campaign against those who were believed to have perpetrated the 9/11 attacks. And this gave the CIA authorities that it had not had for decades. The CIA had very much gotten out of the killing business for the most part, in terms of the targeted killing business, since the mid-'70s, with the revelations of the Church Committee, which aired all the CIA's dirty laundry from the early decades, like the assassination plots, the coup attempts. And so the CIA was sort of trying to, during those decades, move back to classic espionage. Obviously, there were secret wars that were gone on, but in terms of targeted killing, the CIA had largely gotten out of it. And then 9/11 happens, and President Bush gives the CIA basically the authority to take charge of these secret wars. And this meant that they had lethal authority to go around the world and capture and kill. In the early years after September 11th, this meant far more capture than kill. The strategy primarily was focused on hunting down al-Qaeda operatives and putting them in prison and interrogating them, whether they were CIA prisons or through renditions, other prisons, Egypt, Pakistan, other countries, and then get intelligence from these interrogations. Now, we all know the controversies surrounding the prison program, waterboarding, the various interrogation methods the CIA used. And so around 2004, the CIA had, up to that point, carried out drone strikes in Afghanistan. There had been one drone strike in Yemen, but there hadn't been drone strikes anywhere else, or targeted killings really anywhere else. 2004 comes, and there's really this shakeup within the CIA, started by this investigation by the Inspector General of the CIA, John Helgerson, who really, in this really devastating report in May of 2004, raised the issue of maybe the CIA was risking prosecution for torture because of these brutal interrogation methods. And this internal report really sent shockwaves through the CIA, through the Bush administration, and as I said, raised questions about, is this the best strategy for the CIA? And the CIA, which is an inherently paranoid organization because of its history, many in the CIA started wondering, is this interrogation detention strategy the way to go? Now, I'm really condensing things, but this will help the conversation. A month later, you have the first CIA drone strike in Pakistan. This is the first drone strike of what would be hundreds of drone strikes. Now, I don't want to draw a direct line. The Helgerson report forced the CIA just to start killing people, but it certainly forced a new thinking in the CIA and within the Bush administration of how to prosecute the war on terror. So starting in June 2004, and later on we can get into the details surrounding that first drone strike against a man named Nek Mohammed, you start seeing the CIA launching drone strikes in Pakistan, which has really been the laboratory for this targeted killing campaign. But it's really, in those early years from 2004, pretty limited. There are, a dozen or so, I'd say, drone strikes up until 2008, the very final months of the Bush administration, when the feeling was, during that time in July 2008, that the strategy wasn't working. The the United States had been relying on Pakistan for intelligence. The drone campaign, which had been limited, had done very little and allowed this new al-Qaeda safe haven in Pakistan. So July 20, 2008, President Bush signs off a secret order that basically allows the CIA to launch a unilateral war in Pakistan, which means do drone strikes, very intense campaign of drone strikes without telling the Pakistanis or without asking permission. So what you see from that point on, the end of the Bush administration into the Obama administration, is this really intense campaign of hundreds of drone strikes in Pakistan that are done without the approval of the Pakistani government. This was, as I said, embraced by President Obama in Pakistan and expanded elsewhere in Yemen and other places. And so you have really where you are today, this situation of a vigorous, quote, secret, covert program that is anything but a secret because we're having a panel tonight to talk about it. And it's anything but a secret, and this sort of wrestling with inside the American government about just what the future should be.
That's a great sort of overview of how we got to this current situation. Just one last question, and then I'll move on. But do you have a sense what the procedures that were followed during the Bush administration before they made a decision to have a strike as compared to the beginning and then later on in the Obama administration? That is, what were the type of protections that were provided through in making these decisions?
So a couple of things, and we'll limit it to Pakistan because really that's been the focus of the activity. As I said, before 2008, you had a process where there was notification to the Pakistani government that the U.S. intended or wanted to do a drone strike. They would ask for permission, and there was this.
Do you know if they ever denied it?
I believe there were on occasions denials, and there was a view in the U.S. government that this early notification in some ways led to tip-offs to militants in Pakistan, and the guys, escaped just before the drone strike happened. So once the new order was signed, basically, as I said, it was unilateral. It was, we're going to do the strike. We, the U.S. government, will do the strike. We will tell you when we do it. Not that it's a big secret. These things do get reported. The other big change around that time was a movement from what they called personality strikes, which were strikes based on specific intelligence about specific people who were on the ground, and the CIA investigates, tracks someone for a while, and they say, so-and-so we know is in this compound, we would like to do a strike on so-and-so. Move toward what they call signature strikes, which are lowering the bar that is required to carry out a strike. You don't need to know specifically who is on the ground. You don't have to, identify who you are killing or who is surrounding them. You can base it on patterns of intelligence, patterns of activity that seem suspicious. I don't want to make it sound like it's too haphazard, but it certainly has led to many instances where wedding parties have been hit, tribal meetings have been hit, because it looks suspicious from the air, and intelligence on the ground indicates there's militant activity. Turns out it's not. So signature strikes was another sort of lowering of the bar for how these operations could be carried out.
And internally within the U.S. government, the decisions were made about selection essentially within the Central Intelligence Agency?
So Pakistan because it has pretty much remained the CIA's war, and the CIA has the authorization to carry out a strike. Up to the CIA director or the deputy director can authorize a strike. When the Obama administration came in, outside of Pakistan, there was an order that if, for instance, about a year into the Obama administration, you saw an escalation of operations in Yemen, the White House and a group of counterterrorism officials from across the different agencies authorized each strike, and ultimately the president approved each strike outside of Pakistan, or didn't approve it based on the information.
Well, the question, of course, is what's the, as for lawyers at least, what's the legal authorization for this? What's the legality of this program? And I guess the best way to think about it is what is the legal defense of both the Bush and Obama administrations in support of this type of activity. And I'll pass that to Claire. Do you want to sort of outline what the defense of this looks like?
So one of the central challenges that both the Bush administration and the Obama administration faces is how to identify who counts as legitimate combatant. Traditionally, according to principles of just war theory, there are combatants and there are civilians, and there's nothing in between. Combatants are typically understood to be governmental agents following a chain of command from a sovereign nation with whom we are at war. Civilians are everyone else. And the principle of distinction says that it's permissible for you to target any combatant with whom we're at war 24/7. They don't have to be doing anything dangerous at the moment. They can be sleeping. They can be filing their nails, or they can be attacking. It doesn't matter. You can, so long as they're combatants, you may attack them, and our combatants are similarly attackable. Civilians, however, may never be attacked. Now, the trouble is suddenly we had this war with members of al-Qaeda who were neither fish nor fowl. They're non-governmental agents. On the other hand, the level of force and the danger to U.S. security certainly rivals that of the kinds of wars that we have encountered in the past. So what did the Bush administration do? Well, they trotted out a concept that had last been used in 1942 in a case called ex parte Quirin, which is the notion of unlawful combatancy. And in that case, there were German saboteurs who were in U-boats off the coast of Long Island, and they had actually donned German military uniforms to make sure that they would be treated as combatants and be given prisoner of war status if captured. And President Roosevelt actually decided not to treat them as prisoners of war and sent them to a military commission where they were sentenced to death as saboteurs. So, and the legal framework for this was that of unlawful combatancy. So the Bush administration said, well, we'll revive that concept because we have a similar problem here, and we will treat members of al-Qaeda as unlawful combatants. And that's to draw a distinction between members of al-Qaeda and members of the Taliban, who are governmental agents and who fit the framework for combatants in the classical sense. Well, now the problem exists. Well, what is an unlawful combatant? How do we think of them with regard to the principle of distinction? Because essentially, they're civilians in one sense, right? Traditionally, they would have been civilians who are non-targetable, unless they are assisting the enemy. You can, of course, always target them in self-defense, but that depends on their activity, not their status. Combatancy is a concept that is status-based. So what we wanted in using the notion of unlawful combatancy was to treat members of al-Qaeda as giving us a status-based justification for detention and interrogation under the Bush administration and later targeting without having to accord them the POW status that they would have if we were to treat them as full combatants in the classical sense. And the trouble is that we have never gained clarity on the justification for that or the meaning of unlawful combatancy under the law. And it has myriad implications that continue to plague our military and our civilian policies with regard to that notion. So, for example, the original authorization for the use of military force shortly after 9/11 does not define unlawful combatancy, indeed does not use the term unlawful combatancy. It merely authorizes the president to use, quote, all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11th. So it does not tell us what appropriate military force is. Clearly, civilians have to be exempt from the AUMF. Now, there was today, in fact, there were today in the Senate hearings on whether or not to reauthorize the AUMF to look again at the criteria for the use of military force, partly because this issue has been so unclear. It also became a major issue in the case of Anwar al-Awlaki, who, as many of you know, was an American citizen who was associated not with al-Qaeda core, but with al-Qaeda on the Arabian Peninsula. And he was targeted in Yemen, and after a series of legal challenges to his appearance on the JPEL list. Now, the JPEL list is the Joint Prioritized Effects list, which is our targeted killing list. We do not know exactly how it is put together and who puts it together, but it is based on consultation. There were several tiers to the list, and the father of al-Awlaki had gotten word that his son was on the JPEL list. He filed an injunction, a request for an injunction, and that eventually went up to the DC Circuit, and that was denied. His claim was that his son's due process rights were being violated by the fact that he was not allowed to know the basis for his targeting. Now, if his son is a civilian, remember he's an American citizen, then the point is very well taken. You have due process rights as an American citizen, and if your government condemns you to die, it needs to tell you why you're condemned to die and what the basis is for the charges against you. Those are the rights that we understand to exist in a criminal law framework and that we're all very familiar with. On the other hand, if he's a combatant, then he can be targeted at any time, and the government does not have to tell you why you have been put on that targeted killing list, and indeed has no obligation to reveal anything about your status. The DC Circuit said, well, this issue is non-justiciable. Primarily under the political questions doctrine, the DC Circuit took the position that Article III courts do not have the power to second-guess decisions about combatancy versus civilian status or anything regarding military operations. And as they said, there is no carve-out for the due process rights of Americans. So as I see it, the central challenge is this. You have broad discretion on the part of the administration, on the part of the executive branch to decide who is a combatant and who is a civilian. You have very extensive use of the classification privilege, which makes it impossible for the public to know what the criteria for identification of individuals on the JPEL list are. And then you have a judiciary that says, and these issues are non-justiciable, so you cannot challenge these decisions on the basis of traditional constitutional rights. That, to many, poses a serious problem or challenge for the rule of law.
And I would throw this to any member of the panel, but obviously a lot turns on the judgment as to whether somebody's a combatant and whether they're an unlawful combatant. What do we know about what processes are actually followed, either in the Central Intelligence Agency or in the White House, to at least get at that question in individual cases?
In general, the question is treated as a matter of the level of threat that the person poses and the degree of connection with al-Qaeda. Now that's a little bit complicated because those are two different criteria and they're not always the same. I mean, remember that al-Awlaki was technically a propagandist, and again, he was not al-Qaeda core, he was al-Qaeda on the Arabian Peninsula. The administration has characterized him as, quote unquote, very active, and that he posed a significant threat, but we don't know the basis for that decision, and indeed we don't know any of the legal framework that stands behind the decision to target or to declare someone a combatant.
But is there a procedure where somebody in the Central Intelligence Agency is sort of charged with representing why this individual should not be considered an unlawful combatant, and then somebody in another position makes the ultimate judgment? How do we know there's at least an extensive dialogue over this question and a chance to really think it through before somebody is essentially annihilated.
Yeah, in fact, we don't know that, and it's likely that the debates, we have pretty good evidence that debates are not carried out in terms of the labels, combatant versus non-combatant, or even unlawful combatancy, but just whether or not this is an individual who ought to be targeted. We have some representation of this from the government white paper that was recently leaked, and now, as you may know, some members of...
This is the Office of Legal Counsel memo?
The Office of Legal Counsel memo, which was written to really to address the al-Awlaki question in 2010.
But the OLC memo talks about the legal justification for targeting people with certain characteristics.
Correct.
It doesn't go into the procedures for determining whether somebody falls into that category.
Correct. And so it's not clear that there are any procedures for actually identifying someone as fitting under the label combatant or non-combatant, but rather the kinds of procedures that exist, to the extent that we understand it, all have to do with whether or not to place someone on the targeted killing list and what the justification for individual by individual putting that person on the list would be.
Just sort of to follow up on this, and again, Mark and Peter, feel free to jump in, but do we know from looking at the people who've in fact been attacked or hit by drone strikes, do we have a sense from looking at those categories of people what actually might be going on in the identification and of targets?
Well, it's hard to know. You can draw some conclusions. There are people who commonly, through reporting or through public statements, you can identify as members of Al-Qaeda, members of Al-Qaeda in the Arabian Peninsula, somewhat, senior members. But then there's also people hit in Yemen or Pakistan or elsewhere who, we on the outside know nothing about. They may be more a problem of Pakistan or Yemen's government. And so, in other words, they're the enemies of Pakistan rather than the enemies of the United States. And there's, as the bar has been sort of lowered for doing strikes to the point where you can't make a clean assessment based on just who is killed, that, there has been this careful process. Now, Claire brought up the Awlaki case. I mean, there is a different process that goes on when you're talking about American citizen as opposed to a citizen of Saudi Arabia or Pakistan. There did have to be an Office of Legal Counsel memo authorizing putting Awlaki on the kill list as opposed to a member of Al-Qaeda who's not an American citizen.
That is, the Office of Legal Counsel had to actually investigate the facts of his case to put him...
That's correct. That's correct, and provide justification for why, in their view, he ought to be killed.
Just one last question. We obviously, the vast majority of these strikes are occurring in Pakistan. What other countries have seen strikes? Yemen, but what others? And is there any geographic limitation in in this legal justification that would restrict it to those countries?
Right. So the 2010 memo deals specifically with targeting Americans outside the zone of hostilities. And so the Office of Legal Counsel has argued for a justification for targeting outside the zone of hostilities, in this case extending to Yemen. And the suggestion, of course, follow-up remarks by Brennan suggested that this could even be the case in the United States, so that it's not, need not be the case that outside the zone of hostilities means next to a zone of hostility, right? It might be next door. So
we all could be in Paris.
That's
and look
right.
up at
There's
the
no
sky
reason there's no reason to suppose that outside the zone of hostility is going to be limited to a part of the world in which we regard the conflict as taking place, at least in theory.
We can all look it up. Peter.
The direct answer to your question is, under the targeted killings campaign, the counterterrorism side, we've seen strikes conducted in Pakistan, where roughly 80% of them have been. Additionally, in Yemen, where the vast majority of the remainder have been, roughly around 50 to 60, depending on how you turn them. And I'll get to that in a sec. But also some in Somalia, and one, it goes back and forth on whether it's confirmed or not in the Philippines, in the southern Philippines. Then you get into the question of, there have been strikes in Afghanistan that you could argue would fall under this, but Afghanistan, to the legal side, sort of goes to, it's a hot battlefield, but they may have been with a CIA or CT mentality. To your question of, well, you could do it in Paris, you could do it in the US. This was the creation of what the matrix was supposed to resolve, which was sort of a series of, and this was a decision matrix that was created. It was basically not just identifying who, but under what circumstances. Basically, the sort of general rule being, is it in a place where we can't get them otherwise, and or it wouldn't cause kind of bigger political consequences. We have this notion that the law drives everything. As the non-lawyer in the room, I hate to tell you that's not the case. So the reason may be that, yes, legally you could make the same argument that you're justified in doing it in the Northwest Frontier Province, and it doesn't matter whether it's there or it's in Paris or it's in Arlington, Virginia. The reality is that the decision is fundamentally different because of the politics of it. And so what you're seeing in a lot of these documents is civilian general counsels within civilian agencies trying to come up with legal justifications for what policymakers have already determined what they want to happen.
I'd just like to point out, Mike, that in a way it's easier to justify these strikes inside Yemen and ultimately inside the US from a legal standpoint than inside Pakistan, because as Mark pointed out, at least the Pakistani civilian government has refused to allow us to conduct these strikes, and that's a violation, arguably, of international sovereignty. But Yemen allows us to conduct these strikes, and if the United States carries out strikes on US soil, we're consenting to our own strikes, as it were. So there were principles of international sovereignty that, were they to be more fully respected, might place limitations on the use of these strikes. But we've consistently taken the position that even countries that won't allow us to put boots on the ground inside their countries are subject to our use of drones inside their territories.
But then you get to, again, the realities of it is that for roughly the first 5 years of strikes in Pakistan, where they were publicly saying, how dare you violate our sovereignty, we were actually flying them from a Pakistani Air Force base. So it was not only, it's very hard to violate sovereignty if you're not crossing the border because you're inside the country, but also if you're flying from that government facility. Then you shifted into a situation where, as Mark laid out, it was not sort of the closer coordination. And then we got into the legal argument that we were notifying them because we would send them a monthly fax and they wouldn't reply to the fax. Then you get into also the question of who's running the government, which in Pakistan is a fascinating issue, which is, as Americans, do we follow the elected civilian government, or is it the military, which is the power that be? And this is really going to get tested now moving forward. I mean, one of the things to note here is that, you know, we act like these are super sophisticated technologies that, you know, in Pakistan, how dare you violate our sovereignty? Snoopy in his World War I biplane could shoot down a Predator. They go just over 100 miles per hour. Any nation that actually wanted to actively stop these could very easily do it. It's more about a series of either official or tacit agreements that have happened that have allowed this. And then you get into kind of the back and forth of how they're labeled or not. One other, you know, while I'm chatting here, I think there's three, we've touched on 3 areas that the policy community, but also the public conflates, and particularly the media conflates. And so it's really important for us to be aware of how these things are getting mashed together. So one is drone strike, targeted killing. That is, you can conduct a targeted killing without it being a drone. We've started calling them one and the same. So when I said 50 to 60 in Yemen, that's partly because some of them may have been conducted by manned airstrikes. The legal side of it, in my mind, kind of doesn't turn on whether it's a drone or not. The drone is an enabler for avoiding some of the tough political questions of sending people into harm's way. But whether al-Awlaki was killed by a manned F-16 or an MQ-9 Reaper didn't shape the legality of it, but we act like it does. Another part of the conflation, which we've touched on, is military versus civilian intelligence. So military drones, about 11% of all airstrikes right now in Afghanistan are conducted by drones, by Air Force calls them RPAs, remotely piloted aircraft. Roughly 45% of all the targeting in the official military campaign is conducted using these technologies. But it's when we cross the border into Pakistan, it's not just it moves outside of kind of, you could describe the white Air Force, official chain of command, overt aspects. We move into the black world side, the not so covert side that Mark was talking about. And that, again, you have a conflation. So you've got CIA mostly handling Pakistan on the counterterrorism side, but then you get Yemen, where you've got simultaneous both CIA and you have JSOC, which is military, but it's black ops military. And that conflation is important not just on the legal aspect, but the strategies and the goals and what they're doing are different. So for example, JSOC in Yemen, the strike that got al-Awlaki, the senior, the father, was a CIA going after a perceived al-Qaeda leader. The one that got the son was actually, at least according to someone on panel here, so I'm not disclosing, was JSOC was military, but was going after someone more involved in kind of, you could argue, part of the contestation within Yemen that's essentially an insurgency that al-Qaeda in the Arabian Peninsula has become part of. And so what you have is not just different statuses and different definitions, but also different goals. Are you whacking top al-Qaeda leaders, or are you helping that local government against militants that are affiliated or not affiliated with al-Qaeda? And then the third conflation is this notion of al-Qaeda prime versus associated forces, which is not mentioned in the original legal justification that you read from. And so that's when you get into many of the strikes are, again, going after militants. A good number of the signature strikes met that standard of, we don't know who he was, but he was in an area doing something bad. Well, that could have been you were running an IED factory or hanging out with these guys. But also, this associated category gets you into horse trading, which is, for example, to get access into Pakistan, we took out Batullah Masood. Batullah Masood was head of Pakistani Taliban. Bad guy, admitted that he was part of the effort to kill Benazir Bhutto. Definite bad guy. But we sort of had a challenge of, he's not part of al-Qaeda prime, not part of going after US interests directly, but because he had killed the wife of a senior Pakistani leader and had been someone we wanted to get, and there's other individuals that are in this category, we expanded the definition to be able to get them sort of horse trading, giving them something, giving the local regime something that they wanted, which was to whack a bad guy. But he was a bad guy, but maybe not bad guy in terms of how the original legal justification defined it. And that's the politics, that's the strategy you get into. But this issue becomes really important now as the definition of who was behind 9/11 and going after them gets tougher and tougher to kind of argue as you get further and further away from it. And you've gotten bin Laden, and to your other question, we've gotten the number 3 in al-Qaeda umpteen times.
But it's always a new number 3, right?
Well, now
we tend to move up the ladder.
We go to 2 because no one else knows that name. But the point being is that you have this sort of, again, a morphing, a mashing that's just like these others and the way we talk about it. And so it's this imprecision that gets abused in both the media discussions, but also how publicly policymakers sometimes talk about it, where they say, oh, this is only going after top senior al-Qaeda officials. And you're like, well, that's one kill list that's doing it, not another kill list that's doing it.
I wonder we could come back to the issue of the technology, because I think I want to underscore something Peter said and to bring out another aspect of it, which is people tend to think it's the technology that's the evil thing here, as though it weren't people operating the technology or the rules and regulations that constrain that technology. And I think it's really important to distinguish these issues. I mean, drones are a precision instrument. And so as such, they have vast potential to reduce collateral damage, and that is correct. The problem is that we don't have very clear policies governing the use of targeted killing generally, whether by drone or by manual power, right? So I think where there's an issue about the technology, it might be as follows, is the fact that we are not as exposed to risk when we carry out these operations ourselves. Does it tend to lower the threshold for our use of lethal force in a way that it would not if we had to expose ourselves? And does it contribute to the violation of sovereignty of other nations because we don't have to respect borders as much as we do? The other side of the technology that I just wanted to put on the table, and maybe the other panelists want to comment on this, is the fact that drones also now have a use for really upholding rule of law values with regard to surveillance, because the drones now apparently have the ability both to engage in surveillance and attack simultaneously. So that the president can actually sit there in the Oval Office or in the Pentagon watching an attack being carried out, and everything that you do as a combatant is subject to instant replay, right? This is much harder to violate rule of law constraints in operations when you're being filmed at all moments.
And these films are kept for review by whom?
Well, that's going to be a growing issue. I've recently learned that there have been attempts to get a hold of these films.
Let me sort of draw this out.
There's an important aspect here to hit, which is first on this note. So the technology is crucially important, but it's important in these you could argue kind of ripple effect ways. So for example, on the enabling factor of the technology, I mean, the movie Zero Dark 30, the Bin Laden raid is a perfect illustration of this, where the president's decision to put a very small team of elite forces on the ground into Pakistan for under an hour to get the ultimate target was still described by his chief of staff as, quote, the gutsiest call that any president could ever make, which we would argue is maybe a bit, we would agree. But there's an irony there in that, notice, no one describes the decision to carry out more than 300 airstrikes into the very same country with the gutsy narrative. It changes the way internally they talk about it, and changes the way externally we all talk about it. So that's the enabling. But the other fact is the ability of the remote technology. It's not just that it tapes things, it's that it enables operators and or their commanders and supervisors to be engaged from afar. And so one of the things that worries a lot of folks in the military, and talking about military operations in Afghanistan, but which hasn't been sufficiently dealt with in the counterterrorism community, is something that's called tactical generaling, which is the notion that senior leaders are getting too down in the weeds because it's exciting, it's interesting. And so we have, basically that you're thinking about the tactics, you're thinking about the killing, not doing the leader's task, which is grand strategy. So every minute that someone either watches that video or debates about killing one person is a minute they're not thinking about, how do I win the wider war? Mark?
Just on Peter's great point about sort of technology changing or developing our thinking on these things. In spring or summer of 2009, Leon Panetta, the CIA director, sort of semi-famously raced up to the Hill to brief Congress on something that he was told when he became CIA director Congress hadn't been told about. And so us in the press heard about this, and we were all very eager to know what was this secret nefarious program that he had just learned about. And it turns out it was a program for the CIA to kill people. And it was killing people with actually small teams of people going into countries and killing them. Now, best of my knowledge, it was never executed or carried out. But it became then known as the CIA Assassination Program. Now, if you thought about it, you'd say, well, what exactly has the CIA been doing with hundreds of drone strikes? I mean, it's the exact same thing, and yet this became known as the Assassination Program because it involved people actually killing, as opposed to the CIA running aircraft into Pakistan and killing by remote control, which is something different than assassination in many people's minds, when in fact, it really is the exact same thing. And you know, the term assassination is now it's there's an executive order, President Ford signed, banning assassinations. So we don't quote do it, and yet we do targeted killings. And there are government lawyers telling us why these hundreds of drone strikes are not assassinations; they're targeted killings. It's the same sort of very similar to the torture debate. Is something torture or is it not?
Just to back up for a second, if you, just sort of to encapsulate the discussion, we started out with, back in the early 2000s, with a response to 9/11, sort of in a sense, a response to Al-Qaeda, and we had to narrowly defend the United States against Al-Qaeda. Legal justification in a certain set of circumstances where we could go after unlawful combatants, a legal opinion to that effect. We then, in a sense, have started a process of warfare, as it were, that has evolved and grown over a period of time, and we're not sure if it's still cabined by even the original justification, whether or not everyone agrees with that justification. But clearly it's very fuzzy and has encapsulated, as Peter said, a lot of other circumstances where we might challenge it. That, of course, raises the whole separation of powers issues at this point, which is this is a program that seems to be run almost entirely within the executive branch without subject to legal standards that I'm aware of, or, as we know at this point, any type of internal review process. There may be, we simply don't know what it is. You know, what should be done about this? I mean, is this troubling? If it is troubling, what should Congress, in a sense, respond with legislation? What should it look like? What would be an appropriate standard for the executive branch internally on its own to follow in these circumstances? Anyone? Mark?
Well, actually, Peter's not the only non-lawyer in the room. I'm also not a lawyer. So,
We're all lawyers.
so I will let others sort of discuss this sort of.
But this is
legal.
a public
Yeah,
policy.
no, it's a public policy issue, and so you know, if you just take Congress, so what was striking for me covering the confirmation hearings of John Brennan, the CIA director, was that the Senate Intelligence Committee, which is the dozen members of Congress who are authorized to have the highest levels of classified intelligence inside the U.S. government, held up Brennan's nomination in order to get access to the legal memos underpinning the targeted killing program. Now, as an outsider, it was striking for me that they didn't have these to begin with. Now, you know, the White House argued there was executive privilege, and but
as to the legal justification.
Right, so they had not seen the legal memos justifying the targeted killing program. Now, if they don't have them, you know, what good is it, you know, how good are any of us in sort of making assessments of the legality of these things? And so, and ultimately, they approved Brennan's nomination without seeing them all. So, you know, I think that a lot of this does lay on Congress's doorstep to, I mean, and both Republican, in contrast to the detention interrogation, both Democrats and Republicans have widely embraced targeted killing. And there has been oversight, but there has not been, I would argue, incredibly rigorous oversight of this program. And so I think one first step, even setting aside the courts issue, is Congress taking a more active oversight role in examining the program.
Oversight in the sense of getting a justification for the program in itself, or getting a better sense of how procedurally the decisions are made?
Well, I mean, getting the legal memos would be a start. In
And
addition,
my understanding is some of the broader OLC memos were released, but the underlying memos were
they
not.
got a few of there's anywhere from 8 to 12 or 6. There's different reports of.
There are about 11 memos from OLC.
Something like that.
About 5 have been released.
And 5 that they weren't released, they were shown to the committees.
Right.
So that's the start, is sort of getting Congress briefed up, or getting the committees briefed up on all of the legal aspects. Now, the intelligence committees say that they send staff over to the CIA to monitor the strikes after they happen. These are after the fact reviews, and I take them at their word that they these staffers do good work. They work hard. They try to, but there is discussion of having much more rigorous oversight, in terms of examining before strikes happen. I don't know whether that's even constitutional. I'll let others sort of weigh in on that. Whether that's practical is another matter. I mean, there are real serious practical issues about how much Congress can do in times when the intelligence is fleeing and that type of thing. But
Obviously, there would be constitutional issues if staffers or parts of Congress could coercively prevent a strike. But a separate question of whether or not they might pass legislation which would set up standards, or at least require some sort of internal process within the executive branch before a decision was made.
And that is, there's various proposals being discussed right now in Congress for either better oversight, or, as you say, mandating more things in the executive branch to, procedurally before strikes happen.
Yeah, before we came out, you had mentioned that the New York Times reported before the election, the Obama administration had been beginning to promulgate regulations about this, or at least putting together procedures, and that has, yet after the election, at least nothing's come out at that point. Do you know where any of that stands at this point?
Well, so as my colleague had reported in the fall, yes, in the frantic weeks before the election, and one reason this accelerated was that there was this view that Romney might win, and so we really need to get rules in place in case he wins, so they're set in stone. He didn't win, we know, so that sort of effort lagged, and here we are months later, and it's still not done. But they are working on what has been sort of colloquially called a playbook, which is rules and procedures for where people can be hit when, who can be hit. It's a little vague about exactly what this is going to look like, but also wrapped into this debate, which we are hearing they want to announce sooner rather than later, but we've been hearing this for a little while, is whether some of the shifts from the CIA to the Pentagon, moving from Title 50, as they say, the CIA strikes, to Title 10, where the Pentagon, in theory, it would be more transparent, although not necessarily so. This is all being worked out now, whether the CIA needs to move out of this targeted killing business and more into traditional espionage. I mean, these are all the sort of things being at play right now.
Peter.
Let's pull back on this. The Constitution, the Founding Fathers, as they wrote it, and let me pull back on what I'm about to say. I actually support the vast majority of these strikes. So I'm not out here to say don't do this. What I'm about to say, though, is that the Constitution lays out that the president's role, the executive branch, is commander-in-chief in war, and that the legislative branch decides when war, so to speak, and funds it. And we've gotten to this weird situation where we have instead interpreted, oh, but I sent a staffer to watch a video after the fact, that's an explainer. Or, well, I did several years later ask a really tough question at the confirmation hearing, which is basically the application process, the job interview. I asked really tough questions at the job interview, asked questions. I asked to get the legal document, which they only gave me some, which is not, you got what's your judgment of document? you would probably give a lot of these documents a B, maybe, and I mean, they're again, not a lawyer, but not greatly written, some of them, because they're going, they're trying to take a policy and flip it to, in turn, the executive branch saying, well, we did talk about it. This individual gave a speech at Oxford that veeringly kind of mentioned it. This is not what the Constitution laid out. And where this gets really interesting is, again, not just now in these not so covert strikes, but the way this is morphing into other areas. So, for example, we were talking earlier about the impact of this in war powers resolution, which is frankly dead. It's been killed by drones and no one noticed it. And it got killed in Libya, not in a covert strike. It got killed in Libya, where basically the argument was made after our initial 3 days of manned airstrikes that when we shifted over to unmanned, when we got to the 60-day mark, the executive branch communicated to Congress and said, you don't need to vote or not, because it's just unmanned, no one's going into harm's way. And Congress went, sounds good. And we conducted 145 more airstrikes using unmanned systems, and they did most of the targeting since. And so we set this really interesting precedent, not just for covert stuff, but for overt use of military force. The precedent, now I would argue it's not a good precedent, but the precedent is, as long as you don't send people into harm's way.
It's not a war.
Congress, no, it can be a war, but Congress doesn't have to play a role.
Under the war power.
Which gets interesting when you talk about situations like Iran or Syria, or when you talk about a situation where it's a Republican or a Democrat Congress versus Senate versus executive branch. It gets really dicey, but that's the precedent now.
But isn't this part of a more general, I don't want to call it abdication of responsibility, but we have a
Hell yeah, Congress hasn't declared war since spring of 1942 against the minor Axis powers. That's the last time they actually voted on a war against Bulgaria.
But there's that is, the drone strikes are the latest example of a fundamental trend in this regard, which is to say that Congress has not only handed over the waging of war, but the effective declaring of war, and that the War Powers Act is not acting as a restraint on this process. And it's true, drones are an example of that, but it's been a long-term process over a number of years.
Yeah, you've basically seen the, so one, you've seen Congress take the lesson from the experience of the 1991 the resolution related to the Gulf War, which is not a declaration of war, but the basic lesson was don't be caught in the same room as a decision to use force or not. Just avoid it. And more broadly in our society, Congress hasn't declared war since spring of 1942. The last college class that had to worry about being conscripted, the last University of Penn class, just celebrated their 40th year reunion. We have less than 1% that serve. Then you get into, well, but there used to be economic linkages to war. You used to get taxes or war bonds. During World War II, American public invested $165 billion of their own money in the war effort. And we also completely changed the tax structure. Last 10 years of war, we bought 0 war bonds and we gave ourselves tax breaks. So there's something big going on here. Drones, in my mind, sort of takes this to the final logical endpoint of a bigger thing that's happening in war.
So the question is, obviously the waging of war is a fundamental decision that a country makes with implications, obviously not only internationally but domestically. And it is, we've moved to a process where that seems to be made by the executive branch alone. And the question is, are there reasons for that? We can get into the political science of it, but we don't have the time. But the issue then is, since decisions of this monumental importance should at least be arrived at after some level of a full discussion, how do we ensure that discussion occurs going forward? How do we, if it's not going to be, if the individual members of Congress have an incentive frequently not to put themselves into that, how, as in structurally, either through passage of legislation or constitutionally, or within the executive branch itself, how do we ensure that process occurs?
If we don't create essentially we had a post 9/11 authorization of force, which was not contemplated for a lot of the uses of force that have since followed. And at some point, until Congress weighs in again, they've created a structure that allows the use of force. Again, until they weigh in, it can be interpreted quite widely, anywhere, anytime, forever. And that's why they, in my mind, need to revisit this issue. And revisiting it is not holding hearings, it's actually doing what you've been voted to do, which is to vote.
Isn't there going to have to be, I hate to say it, but some sort of horrible misadventure before we as a country are going to address this issue? I mean, we can say, yes, Congress should step up and pass legislation or become more involved, but are they likely to do it absent some sort of cataclysmic event?
That's a good question.
Any more before I really do want to open it up to questions from the audience, but any more comments?
What I was going to say briefly is, just to answer your original question about separation of powers, as I see it, there are three broad types of solutions out there, and you've been discussing various of them, but I just wanted to give an overarching framework for that. One is to increase transparency. So, that's a core part of a deliberative democracy, that not only Congress but members of the public can get involved and can help shape moral guidance for our country only if they are informed.
Can I just sort of it's a great point. What's intriguing is that the underlying legal justification for the decisions hasn't even been released as a matter for public discussion, which is
that's correct.
It's at least not knowing what the documents say. It's hard for me to understand what the security justification is for not releasing
And what
that.
we've seen since 9/11 is an increasing use of the classification privilege, and the executive branch is largely self-policing in that regard. So it's very hard for other branches of government to come in and challenge the expanded use of classification, because if we don't know what we don't know, right? So now FOIA is the way that such challenges have wound their way through the court, and those have been largely unsuccessful in recent years, not surprisingly. So, so transparency, a central value, but also a central challenge in a time of very great national security needs. The second way is to have increased use of the judiciary. And because Article 3 courts have taken the stance that they can't second guess executive discretion in these areas, a lot of people call for use of FISA courts or special national security courts. So that's a second broad heading.
That is, create some sort of procedure about the selection of individual targets that would be subject to some
Not just that, I mean, the idea of going to special courts has been proposed in a variety of contexts. Indeed, there was a suggestion, well-known suggestion, that you could get a torture warrant, right, back when people were debating torture and enhanced interrogation techniques. So the idea that there should be special courts with special jurisdiction is a very commonplace suggestion these days, and we could debate the merits of that. And the third you've been talking about a little bit more, which is increased congressional activity to authorize war. And that's, so I would think of the three solutions as increasing transparency, number one, number two, increasing judicial activity in various possible ways, and number three, enhanced congressional activity.
Either in the form of substantive legislation or oversight.
Exactly. Those are the broad headings that we might be thinking about in this regard.
Questions? I think we have mics that we can bring over. This gentleman, then we'll move. Yes.
My name is Reed Albano, and I'll preface this by saying I'm also not a lawyer. but incidental to the killing of Anwar al-Awlaki was also killed Samir Khan, who, if I recall, was the editor of Inspire magazine. And I just wanted to ask, if I recall correctly, he had a pending legal case against him in North Carolina. So does the fact that he was extrajudicially killed at the same time as Anwar al-Awlaki set even an additional legal precedent in that particular case?
Claire can talk to some of the legal aspects of this. From what I know about the case, there was a debate about Khan and whether Khan should be, like Awlaki, specifically targeted. And to the best of my knowledge, that there was not an OLC opinion about, unlike Awlaki, sort of authorizing killing him. He was with Awlaki. It's still unclear whether they knew when they took the shot on Awlaki that he was collateral damage, whether they knew in advance or only knew after the fact. But it was, so he was not. There was the legal proceeding going on, and then he was killed. So it's a different case of Awlaki, and I'll have Claire if you want to discuss the.
Yeah, I mean, it's not at all clear whether or not Samir Khan was collateral damage, basically, and also defined collateral damage. And then, of course, 3 weeks later, al-Awlaki's 16-year-old son was killed, which at one point we openly pronounced to be a mistake. Then we sort of took it back. This really underscores the lack of criteria here. And as Mike, as you raised before, what's the framework in which we decide this? Do we actually label people under the heading combatants or civilians? No, we just debate whether or not to kill them, case by case, person by person. So part of the problem is that we don't have overarching principles under which to fit these cases, and partly we decide later, as we did in Samir Khan's case, whether or not this person should count as collateral damage, and sometimes we change our minds. So I think it just underscores the lack of principles and framework here.
Yes, ma'am. Sorry.
Hi, thank you. Pat Reber, I'm a correspondent for the German press agency. I wanted to ask you if there is any toll. We talk about drone killings as being the sparing a person, sparing a military pilot, but is there any toll at all on the people who operate the drones from New Mexico or Arizona or wherever that is? Are you aware of any?
By toll in the sense of?
Just
psychological,
PTSD, psychological depression, anything like that?
So again, this is where we risk conflating. So you asked about the military person operating it from now. So I'm going to answer that, but we're at a discussion about targeted killing. We're at a discussion about CIA drone strikes. So take what I'm talking about is what we know about the overt U.S. military use in Iraq and Afghanistan. And essentially, there's been a series of studies that have found either comparable or higher levels of combat stress and fatigue and burnout. Sometimes people call this PTSD, other times they're not. Again, legal issues matter here, so for a long period of time, legally, someone in the Air Force could not get PTSD if they were not physically in a combat zone. It's a medical condition. It's sort of like dealing with an HMO. Legally, do you have the disease or not? But the point being, they found comparable levels in a series of studies. Then you get into so first, that's actually a powerful illustration of something that is contrary to how the media depicts it, which is this notion of, they treat it like a video game. They treat it like, they're playing a video game. Well, the very fact that someone's dealing with this toll shows that it's actually not that they don't care. It shows there is a psychological impact. The video game effect of it is something that Claire brought up and I talked about, which is I see the video game effect more on the public side, that we can be at war but not really be part of it. So then you get into the question of why is it they're experiencing this? And no one has a good answer. There's lots of different theories. It's everything from they may not physically be there, but they're actually seeing more of killing than a bomber pilot would. They see the before, they see the after. A different part of it may be the psychological disconnect of killing and then walking outside and you're in the United States that's not at war. Another part of it may be unit cohesion. The units never together all at the same time, which is one of the key inoculators to PTSD. It's more like shift work. Another may be the consistency of it. The war never ends. It's every day. And so one of them described it to me, it's a lot like being a firefighter and there's a fire every day. It just kind of grinds you down. Another part of it may be the weird aspect of being near your family. So the Air Force regulations require, you can physically fly from Afghanistan back to the United States within roughly 12 hours. Air Force doesn't allow that. They say, actually, we want you to decompress, and they actually decompress in Germany for 3 days before you come back. The UAS operator can be at their dinner table within 30 minutes. And so it may be a psychological decompression. Lots of different theories. But bottom line, there's impact. And again, where this is interesting to our topic today is you have a CIA that was an intelligence collection gathering agency and has also become, as Mark writes about, it's an agency that's at war. And it, in turn, may or may not have psychological issues that folks there are dealing with, either the people that have physically deployed into places like Afghanistan consistently, to the people that are doing the targeted killings, but does it have the structures in place for that? And at Brookings, we actually had, last year, a psychologist from the intelligence community who was interested in these issues and exploring the psychology, not of terrorism, but the psychology of counterterrorism, which is a field that is literally new.
Yes, sir. Yeah.
My name is Chris Munch. I'm a Penn grad, but I've been associated with the Army for the last quarter century, and was involved in the early testing and evaluation of experimentation of reconnaissance drones in the late 90s. First of all, I'd submit to you, when we talk to the technology, the United States entered the unmanned, what we then called unmanned air vehicles, about 15 years later than most of our near-peer competitors internationally. Drones were used both for reconnaissance and for other purposes for many years before. That said, there's a couple things that have come to mind. Is that when we are, in the last 12 years, we have had transnational threats right in our face. And when you face evil, you have to do something about it. And when you have something, you have to do something about it. So to walk that back to where we are with in this discussion, where do we need to change? Because I think there is some review. Do you think there is some review needed of the Hague Conventions of the Law of War and the lines between Title 50, Title 10, and intelligence oversight with EO 12333 and so on? Because to me, as a warfighter, I can't see letting something go when you see it. When you see someone that is an IED maker, when you see something regardless of their geography or nationality, they're just as evil. When you see it, what do you do about it? And where do we need to redraw those lines and those very fundamental principles?
Well, this goes back to I think one of the points Claire made initially was we have sort of a law of war, and there is a sense of who the combatants are and who the civilians are, and a clearly delineation of what constitutes war, and then we have a law enforcement for civilians. And the problem is those have been conflated. Now, and where the lines are going to be drawn between combatants and non-combatants. To say that somebody is evil, obviously, who can defend evil? But the question is what processes you go through, what criteria you go through to identify somebody's evil, to make sure that that person at least meets certain standards or criteria, as opposed to happens to be sitting in a restaurant in Paris and is perceived to be evil. And these are questions, in some sense, these are questions that go back to the beginning of time and the beginning of war. But the sort of the amorphousness of the war on terrorism has brought them into stark relief. As we try and draw these lines, what I think everybody has agreed on is while there are values to the drone program, the question is there an apparatus in place, we don't know, to ensure some degree of rule of law principles of that.
I think one way to answer your question is to say, just following up on what Mike said, what is a matter of national security and what is not? I mean, recently we learned that everything's a matter of national security, including obesity. Well, I actually understand there's a basis.
I didn't hear that one.
Yeah, there's actually a basis for this, which is that a very high percentage of the American public is apparently too obese to serve in the military. So that, this has become sort of a joke that, yes, everything's a matter of national security, but in fact, and potentially everything is a matter of national security. That way of thinking about evil, right, runs together a lot of things that we're used to keeping distinct. And it implicates separation of powers. It implicates states' rights versus federal rights. It implicates the integrity of our law enforcement and the protection of constitutional rights. So it really is a matter of the categories under which we approach evil and what kind of evil it is and what kind of remedies we have for meeting that evil.
But there's, to get to your point, I mean, there are individuals that in the parlance, you define them as evil, that in some way, shape, or form are irredeemable and in situations where you can't get them otherwise, for real national security reasons, you will decide to put them in the dirt. Period. The question is, who should be doing it and under what processes, and doing it not just in a way of transparency and legality, but effectiveness. So my inclination is that when this shifted from onesies and twosies into an air war campaign, more than 400 airstrikes, several times the size of the Kosovo air war as an example, it shifted into something that strategically would have been better handled by military professionals who would have been very troubled by a whack-a-mole strategy, but also legally would have been better. And look, I'm biased here. I'm the son of an Army JAG officer, but there is a fundamental difference between the way a civilian political appointee and a general counsel, a civilian general counsel, approaches a legal question related to the use of force versus a military lawyer. It's not only not within their training, but also they think in terms of kind of how do I authorize it, how do I justify it, versus a JAG will throw up the red flag because most importantly, there's real consequences. Actual court-martials happen, unlike in the civilian intelligence space where really people only get prosecuted if they leak. At least that's been the track record of the last 20 years. So you have examples on the military side in Afghanistan of airstrikes that went bad, investigations, transparency, potential court-martials. And so that's why not only the JAG raises the red flag, but people listen to their JAG. And again, so all of this, when you engage in war, I'm more comfortable with professionals at war handling it. And I'm also kind of troubled by how we've redefined things to enable us. So, you talked about Title 10 versus Title 50. Well, Mark, I mean, how many people have you talked to that use the phrase Title 60, which doesn't exist? And yet we use it, oh, well, I'm wearing my Title 10 hat versus my 50 hat. And where this gets really interesting, moves it beyond just drones, is this cuts across to areas like cyber warfare versus cybersecurity. And so we've got to start to lay out the structures, not only to keep it legal when there's people that maybe it's not so clear that they're evil and need to be put in the dirt, but also just to do it a lot more effectively to protect the national security more effectively. And that's what, I was talking with someone last night and they said, there's a line which is pretty much every major foreign policy scandal in the US was a product of short-term thinking.
And that was very eloquent. I just very quickly add short-term thinking and decisions that are often made in secret among a very small group of people throughout our history have tended to be decisions that look poor in retrospect, right? And so we now have this war that is is waged in secret, where very few people have really insight into how decisions are made, and that's how bad decisions are made. And it's, I think, sort of the general agreement of everyone up here is that it's time to put a framework around this and bring it out of this shadow where where everything is made in secret, and there is more transparency, there is more accountability. I think this structure is kind of a mess right now, and whether it's Title 10 or Title 10, I mean, it's sort of meaningless. We're far past the point, nearly 12 years after 9/11, where these decisions can continue to be made on the fly.
We'll take one last question, but I want to underscore this point, which the military, since it's been over hundreds of years, been involved in the exercise of coercive force, has created a structure and an accountability standards that is more comfortable in dealing with these situations, and paradoxically may be better positioned to provide an example of how we would sort of structure these type of decisions. You've argued elsewhere that this should be, I think, moved back to the Pentagon for those reasons, as a way of restricting it. Yes, sir. Yeah. Yeah.
All right. So I'm going to basically preface this with saying I don't know that much about this issue, but sorry, my name's Sam and I'm from the Diplomatic Courier, but I kind of wanted to have you guys talk about, sorry, my heart's going really quickly right now, about about the efficacy of drones, because I've sort of heard a lot about the law and whatnot, but I was curious more about how effective they are as weapons, and sort of to use this abstract notion of whether we're unknowingly creating our own demand for terrorism, because right, we know this to be true, that in terms of terrorists, their primary recruiting tool are madrasas, which bring in disaffected youth, right? And this is in the Pashtun region and other places, right, and like Pakistan, which you mentioned. And so I'm curious that if sort of the specter of drones and this perceived lack of humanity which they bring to the table is actually driving up demand for terrorists in these regions by giving jihad this convenient argument against the way that the United States wages war and interacts with the place that they live in.
So what's the international reaction to drones?
Well, that's what you're asking is an example of a strategic level question, which is when you treat it like, there's different descriptions. The CIA director described it as the only game in town, or someone else described it as mowing the lawn, or I used the whack-a-mole technique. Or decapitation is another strategy. Are those actual strategies that lead you to success? Your end state, which is defeating the organization itself such that it never comes back, or that it doesn't metastasize into something else. So you, for example, said, well, these terrorist groups are recruiting from madrasas. That, for example, didn't describe the Times Square would-be bomber who ironically got into terrorism over his anger over drone strikes intended to end terrorism. It's not to justify him. I'm just saying what you're getting at is, where I come down on this strategically, is that understand every time you use force, you may, to the prior question, get the evil person that deserved to be put in the dirt, but there may also be collateral damage effects on those around them and or ripple effects on the politics. And so sometimes it will be worth it to get that high-level individual. But other times there may be low-hanging fruit is another terminology that's utilized, and maybe some of the signature strike folks fit into that. Other times it may not be worth the blowback effect. And so that's the kind of back and forth, that's the kind of serious debate that strategically you want to be having.
Is anybody having that debate?
Well,
Do you know?
this is where we get into what are the goals in mind
Right.
of the players, and some people want to have that debate. And a particular back and forth between the CIA and the State Department was over that of, for example, the timing of drone strikes. The State Department pushing back, saying, don't do this right now in Pakistan because we, for example, have the Secretary of State's about to arrive and is about to yell at the Pakistanis about something, and if you strike, it's going to give them something to yell back at us. And then you get into interagency things where CIA goes, kind of screw you for telling us what to do. We're going to do it anyway. What I'm getting at is you've got different players thinking about these different things, and again, it all depends on what agency they're from, what their strategy is, and also are they a political appointee or not. So, again, a difference between civilian and intelligence. The previous chief of staff, two chief of staffs back in the White House would, at least according to reporting, each morning ask the targeting team, who did we get last night? Which is, if they did that to a military group, it would be impossible. But when you're talking about civilians, that's appropriate. But again, pull back from it. Politically, it may be appropriate. Strategically, thinking, who did we get last night is not how you win.
Just look at within the CIA. CIA is a weird organization, right? It was set up as an analysis organization and an operations organization. And part of the operations are not just collecting intelligence, but doing paramilitary type operations like drone strikes. You have one part of the CIA that's carrying out targeted killing operations, and another part of the CIA that's supposed to be analyzing the impact of the targeted killing operations. And if they're doing their job, they should be asking questions like you asked, which is the other part of the CIA creating more terrorists than they're actually killing? I mean, there's an inherent, and there's one guy at the top who's not only overseeing the analysis, but he's overseeing the operations. Now, some would argue that it's insane to have a structure that way, but that's the way it is. And I do think that there is, those questions are being asked, but I think that they started getting asked in a serious way late in the game about, just what are the ripple effects of this targeted killing campaign. Rumsfeld famously asked, are we creating as many terrorists as we're killing, or creating more terrorists than we're killing? It's a pretty good question that still, I think, is pretty relevant today.
We'll do one last question, okay? And yes, sir. Yeah.
Thank you. I'm Dr. Samantha McDermott. I'm an alum, as well as an academic. And in general, I found many of the questions on both the podium and days, as well as in the audience, very on point. My question to Peter, to some extent, and my family's been in the military for better than 170 years at this point, is that when we look at the structure of war decision-making, the decision to go into it, and since 1945, the international political definition of declaration of war since the development of modern total war is that when you declare war on another nation, you have declared modern total war on it, unleashing the possibilities of weaponry use, etc. No one wants to go there because of nuclear weapons, other weapons of mass destruction, and so forth. So, in a sense, don't you think that what has happened with the decision to actually go to wars since World War II, since 1942, has been an ad hoc process of congressional authorization for presidential commitment of forces, Korea, Vietnam, the Gulf, etc. And in a sense, there hasn't been a dialogue on the strategic level, you've referred to a number of times, as to is there some kind of structure that can be put into place that's not the framers' form in a 21st century world where wars may be against other nations or they may be against non-governmental operators. And what's your opinion on that?
Peter.
It's a big meta question, and I'd love to hear your thought on a particular part of it, which is that you're exactly right. We've seen a change, and it's not just the change in how war is authorized, but it's our very formal definitions of war, but also of when and where war begins and does it end. And we've seen this in lots of different ways, we now call it the Korean War, but Truman called it the police action. And technically it's never ended, but none of us would say we're at war in Korea right now. And then, you get to the other end of the spectrum where this morphing, the national securitification of everything, the war on drugs, on poverty, on Christmas, on sugary drinks, on obesity. And so this terminology gets thrown around so much to then again, it's, legally, the war can be happening anywhere and everywhere under and so you get this amorphousness that's out there. And the real challenge that technology presents to this, set aside the political shift, the challenge that technology presents to it is that our politics and our laws conceived of war in the traditional manner of carrying out acts of force, not necessarily in states, but basically things happening, killing, explosions, basically acts of force, kinetic action, going hand in hand with human risk. So it was the idea that people, when a nation went to war, when an individual went to war, they were going to enact bad things, but at the risk of bad things happening to them. That's whether you're talking about the Trojan War or World War II or whatever. What technology now offers is the disconnection of these two things that we thought went hand in hand. That you could carry out kinetic action either as an individual or a state without having to send people into harm's way. And that's what links drones to new issues like potentially cyber. And we just haven't caught up to that conceptually, but also legally, and yet that's the reality of the rest of the 21st century.
I think the big picture here is sort of the death of war overall. Because what we have over time is the loss of location of war, right? First we lose the battlefield, we have expanded war, greatly expanded territory, and now we're looking at the ultimate loss in location of war, namely the fifth dimension, or cyber war. We have the disintegration of the state, which contributes to that, so you no longer have state actors fighting other state actors. You have the loss of the locality of the combat, as Peter is saying. So the big picture is that war, as we know it, has slowly been sort of dying over time. And what we have is a square peg in a round hole. We have a traditional conception of war as based on principles of symmetry and reciprocity. And then we have the realities of what war is. Also the time, there's no beginning, there's no middle, no end. So we have to reconceptualize what we mean by war.
I think that's a great way to end this discussion with what we have been talking about is how to deal with changing conceptions of warfare and who the bad guys are and how you respond to a legal system that really is not up to the task in terms of the procedures, in terms of the protection of rights. And the question I think we all agree is how to establish a legal framework that will be sensitive to the new realities of warfare while maintaining our core principles about who we are and what the rule of law means. Anyway, this has been a fascinating discussion. I can't thank the members of this panel enough for really all that they've given to the topic. I want to thank Mark Mazzetti, Peter Singer and Claire Finkelstein. Just a note, Mark's incredibly hot book is available outside, and he will be happy to sign copies of it. Claire Finkelstein as well has her book, which has been extremely well received. Peter didn't bring his book, but you should go out and buy it in your local bookstore. And I want to thank the audience for some great questions and members of the panel with grappling with a very provocative issue. Thank you all.